Okay, now that the Wayfarer versus Lively case is completely gone, it's either been dismissed by the judge or they've abandoned the claims that they had the right to replead. I want to talk people through whether and to what extent some of the claims and some of the facts made in those complaints remain in the case. And the first place we really have to look for that is all of the affirmative defenses that have been pled by the Wayfarer parties in response to Blake Lively's complaint, which is the only complaint left in the case. So when you respond to a complaint, and I think I did a video on this a long time ago, when you respond to a complaint, the document you file is called an answer, and you literally answer every single paragraph of the complaint. You say, as to the allegations in paragraph 2, those are admitted. As to the allegations in paragraph 3, those are denied. Sometimes it's a combination of the two, admit this but deny this. You have to go every single paragraph and you have to say which things you admit and which things you deny, so that when you hold the complaint and the answer up next to each other, you know which things are in dispute and which things are not in dispute. And the things that are in dispute become the fact issues and the legal issues that are litigated in the case. Frank is being very needy if you see me looking over here. I have to scratch his head while I do this. So in an answer, you go through and you answer the allegations, and then you state what are your affirmative defenses. So when you are the defendant in a case, part of your defense is just saying the plaintiff hasn't proved their case. So you defend yourself by saying, it wasn't unwelcome conduct. It wasn't severe and pervasive, right? You just go through and try to keep them from proving the elements they need to prevail. But the second thing you can do as a defense is to assert affirmative defenses that you have the burden of proving. And affirmative defenses are what we call, at least all the lawyers I've ever worked with, we call yes buts. So what an affirmative defense says is, even if everything in the plaintiff's complaint turns out to be proven, even if they can supply evidence and prove every one of those things, they still shouldn't win because there are legal concepts that keep them from prevailing in whole or in part. And those are called affirmative defenses, which is exactly what it is. It is a defense that you affirmatively push. So it is a yes, but. Even if everything you said is true, if I can prove these things, you still can't win. So quite some time ago, all of the Wayfarer parties, individually and separately, filed their answers and affirmative defenses to Lively's amended complaint. Each one is its own. Baldoni has one, Wayfarer has one, Heath has one, and so on and so forth. And I'm not going to show you all of them because they're super boring, but I'm going to tell you about the ones that matter. So see where it says affirmative and other defenses? By alleging the following defenses, defendant is not in any way agreeing or conceding that he has the burden of proof, whatever. That's just standard language. And then it lists, and this one has, I think, more than 20, affirmative defenses that are yes buts. So there are many things that are in the case that allow the Wayfarer side to get discovery on these things because they have made them factual and legal issues in the case by pleading them as affirmative defenses to Lively's claims. So I went through them and I looked at them all, and I'm going to tell you the ones that I think probably match the closest as to what the Wayfarer complaint and case was when it was live, and the things that make the most sense to me as things that they would want discovery on based on the issues in the case. So you can see in number 1, the complaint and each claim alleged therein fails to state facts sufficient to constitute relief. That is just the motion to dismiss standard as a defense. Little known fact is that you can file a motion to dismiss anytime that you want to. You don't have to file it in response to the complaint unless it's a motion to dismiss for personal jurisdiction. But otherwise, you can bring it up later. So the fact that the plaintiff lacks the facts in their complaint to actually seek relief appropriately is something that you can raise anytime. So they have reserved the right to make that argument by putting that in that first affirmative defense. And then you can see as you go down in there, look at Look at the second defense, paragraph 484. The complaint is barred as plaintiff lacks standing to sue. That goes to the Blakel thing. Blakel loaned her out, and now she's suing as Blake Lively, the individual, for breach of a contract that Wayfarer had with Blakel and not her. So they've preserved that issue there as the second affirmative defense, and that allows them to do discovery on that issue. If you look at the fourth affirmative is too hard to explain. Fifth defense is unclean hands. This is sort of a general equitable concept that's like, you didn't come into this clean either. So even if you prove everything that you're supposed to under your claims, we still have the right to argue that we shouldn't be responsible because you didn't come into this clean. It's a lot more amorphous. I can't really tell you exactly what you have to prove, but pretty much everybody pleads it as an affirmative defense. And again, that allows them to do a broader scope of discovery on what Lively did or didn't do. The sixth defense down here is her claims are barred because she hasn't been damaged by the defendant's actions. That is a causation affirmative defense, right? So we know she has to prove causation for every one of her claims because that's how civil law works. So this is them saying in an affirmative way, whatever damage you sustained, we didn't cause it, you did. That probably goes most likely to the retaliation claims. And if your reputation took a hit, that was because of you and not because of us. Down at the bottom there is your claims are barred in part or in whole by the First Amendment to the Constitution. So again, this is a legal argument that they are preserving that they can make down the line. So I think that probably has, it's pretty common to plead First Amendment when you have discrimination claims, because remember that discrimination is a carve out to the First Amendment. So if something falls short of discrimination, it is free speech. So I think they're making that argument there. I think this might also be a place where they bring in the Baha'i stuff to say, to the extent that he was huggy and kissy and weird, that's because of his religion, and therefore that's not sexual harassment. So they're preserving that argument there. So I'm not going to show you the rest of them, but these are the ones that I saw that I think are very similar to the conversations we've already been having. They have an affirmative defense that she consented to whatever happened, that she didn't mitigate her damages, meaning if her reputation was bad, she didn't try to make it better, she made it worse. That she caused her own damage, kind of that same thing as before, but they state it again. And that there was no proximate cause. In every civil claim, you have to show that whatever the thing is you're claiming the person did to you was the proximate cause, the but-for cause of whatever damage you sustained. So they have several affirmative defenses that say, even if your reputation took a hit, something other than us caused it in whole or in part. So that is very much still in the case. They have an affirmative defense that her damages are too speculative. Right? So she's going to have to prove those damages, but they also have an affirmative defense to that of there's no way for anybody to actually know what those damages would have been, which again allows them to do discovery. And then they have a pretty typical affirmative defense in civil cases, more so in like personal injury cases, but it's this apportioning of fault, which is maybe you prove all of the things that are in your complaint, but it's not, that doesn't automatically mean we're responsible for all of it. You're responsible for at least part. And that leaves that issue in the case, both as a fact issue and potentially as a legal issue if you got to a jury, to be able to have a jury instruction that says, even if you find that Wayfarer did these things, do you find that Wayfarer is entirely at fault, or should some of the fault be apportioned to Lively? So I hope that's helpful in understanding which of these things are still in the case. I think we're going to see as the judge processes some of the discovery things that are coming up now, how much Lively pushes back on things that were in the Wayfarer complaint that are gone. But a lot of it is still very much live because of all these affirmative defenses they have pleaded. This is not something that's sexy, and so content creators don't cover it, but it is incredibly important because, as I have told you before, in any civil case, the complaint and the answer and affirmative defenses are the blueprint for the entire case. So now you have both.